On the court, please. The Honorable Supreme Court, sorry, the Honorable Supreme Court of the State of New Mexico.
Good morning. You may be seated. Thank you. Morning. We're on the record S-1-SC-40286 El Paso Electric Company versus New Mexico PRC. Talent, you may enter your appearance, begin your argument. You have 22 minutes.
Jeff Wexler on behalf of El Paso Electric. Mr. Chief Justice, and may it please the court. In 2023, the court held that the rates adopted by the Commission in EPE's last rate case were unlawful and violated EPE's due process rights. Unfortunately, we're back here today because on remand, the Commission refused to allow EPE to recover the unlawful underpayments. The question of first impression that is presented in this case is whether the rule against retroactive rate making precludes recovery of undercollections or the refund of overcollections that occur during an appeal, even when this court rules that the underlying rates are unlawful. Or put another way, does the law prevent recovery of the ill-gotten gains from unlawful rates that are charged through the pendency of the appeal? The answer to that question is no, for 4 reasons. First, basic fairness requires a rule that allows collection of unlawful underpayments or refund of overcharges following a successful appeal. Any other rule would unfairly harm the party that's been wronged. Second, judicial review is a fundamental part of the rate-making process. Rates that are authorized by the Commission order are not final for rate-making purposes until after judicial review. That means that rates are subject to adjustment when, as occurred here, the court vacates and finds that those rates were unlawful. And those adjustments were not retroactive because they're treated as part of the same case. Third, if the court overturns a rate case order, as it did here, that order is vacated and remanded as if the rates never existed. In other words, the adjusted rates are treated as if they were in place at the beginning of the case. And fourth, to have any kind of meaningful judicial review, it's necessary to allow recovery of unlawful underpayments or a refund of overcharges. Any other rule would provide no meaningful relief. Because the Commission erred on this question, the court should vacate and annul the final order on remand and provide guidance that EP is entitled to recover the unlawful underpayments. Unless the court has questions at this point, I'll start by discussing the reasons that collection of underpayments or refund of overpayments is not barred by the rule against retroactive rate making.
Wasn't the simple path for your client to seek a stay?
Your Honor, certainly that was a possible path and that remedy is available, but it's not the only remedy. The statute gives discretion to both the litigant and to the court as to whether a stay is granted. So it would be a very unusual result if this court were to rule that that is an exclusive remedy for a utility, especially since it's not an automatic stay as you see in some of the other cases. Second, that the rule, if adopted by this court, would place a very significant administrative burden on the court in the sense that it would really be malpractice for any utility or participant in a rate case not to seek a stay at the end, first before the Commission, then before this court. As you know, stay motions are very complicated. They involve a consideration of the merits. So there'd be significant pressure on this court to speed up that process. And that's not a favorable rule, given that these are very difficult, complicated questions. And the reason that's true, you'd face some pressure to speed that up, is if you didn't adopt our rule, then you wouldn't be able to recover those amounts that happened before the stay. And as you can see from Mountain States and US West, those amounts can be very significant. I mean, they were up almost $2 million in US West per month. And there wouldn't be any ability to recover. The third reason I don't think that that's a good rule is it wouldn't provide complete relief. And so you would have no relief before the stay happened. You also would have no relief in those cases where the court simply denies the stay. And as you know, oftentimes there's 9, 10 issues before the court in these rate cases. And you might vacate and annul because you agree with one of those issues. But under those circumstances, if you adopted that rule that is advocated by the interveners, there'd be no ability to recover those amounts, those overcharges or a refund. And then the final thing I'll say on this point is that every other state that I'm aware of that has a similar statutory scheme has rejected that argument that a stay was required. So, short answer, that was available. There were important reasons why El Paso
Not exclusive.
That's exactly right.
What? Oh, go ahead.
Go ahead.
Along those lines of the stay, if we entered a stay, let's say in hypothetical case, and we ended up reversing, it was incorrectly granted, what would be the remedy in that circumstance?
Well, if you adopt the rule, if you follow the rule of the commission and the interveners, there would be no remedy. In other words, there'd be no ability to recover the overcharges or a refund for over collections. And so you'd have basically a wrong without a remedy. Whereas our rule suggests, if in the event that you vacate and annul, what we know is that means that those rates basically never existed in the first place. That's the meaning of vacating and annulling. It goes back to the original place. And really all that's happening here is what happens on a regular basis with courts. And that is an adjustment is made to ensure that the order of the commission conforms to this court's ruling. And so that's why when you look at across the country on cases that have actually considered this issue, and not just the rule against retroactive rate making, which we have no quarrel with, but in this particular set of circumstances where there's an appeal, those cases that have considered, are you able to recover those overcharges or get a refund? And the very strong majority of courts has said yes. That includes the federal court. You see it in the U.S. Supreme Court. Our review says 16 different states who have considered this issue have a rule that's similar to what we're suggesting, and only 2 on the other side. Now there are, to Justice Bacon's point, there are some states, South Carolina is one, that actually have an automatic stay and then a bond requirement, and that sort of takes care of this issue.
So slightly different question. I want to understand, or I want to discuss, not understand, I want to discuss kind of the underpinnings of the, what I'll call the retroactivity rule. And it seems to me, because that is kind of given life by mountain states, that there it was, the rule was tethered to due process in a way. In that in mountain states, they were trying to backdate the order.
That's right.
And so, there's no notice and opportunity to be heard in that scenario. Whereas here, the increase in rate to like X plus 1 is the way I think of it. X
Sure.
plus 1 is prospective because it was subject to hearing and there was an opportunity to be heard once there was remand. Is that a fair way to think of this from your perspective? I know they're going to disagree with me.
Yeah, I think it's a fair way to look at it. Courts have, when they're talking about retroactive rate making, have talked about due process, but really the rationale that this court has articulated, that other courts have articulated, is the idea that, when rates are made, just to back up and take it to that level, and then I'll certainly discuss your issue. What the commission is attempting to do is establish the amount that the utility can charge for a given service. Now, because the rate making is policy driven, this court has held it's basically legislative in nature. And because it's legislative in nature, the court has then gone on to say both, 2 things. Number one, the court really can't do rate making. In other words, you're not in a position to be setting what a fair rate is. And number 2, it's prospective only. So, when you're setting a rate, what you're trying to do is basically allow a utility to earn its revenue requirement, its cost of service, budget plus a reasonable rate of return. But sometimes that doesn't happen, and a utility either does not earn enough to cover its cost of service, or it over earns. It earns more than it's entitled to in terms of its rate of return. And it's under those circumstances that, oftentimes you have to go into a new rate case. It's retroactive when what the commission does is say, hey, we're adopting a new rate here to try and make up for the fact that you made too many profits or to make up for those deficits. Now, the prerequisite to that is you have to have two valid rates, right? The first one that was in place during the time there was a deficit, and the second one where there's a new rate now trying to make up for the old one. The argument that you hear from the other side is they say basically, yeah, you have that here. You have the original rate that was issued in the rate case, and then you have the one on remand. Now, the problem with that is neither of those things are true, because what we know is, first of all, this is all part of the same case, right? So we're not talking about a brand new rate. And secondly, as they point out in the papers multiple times, they suggest that that rate that was in place at the time that the commission adopted in the unlawful rate order, that was a valid rate, at least during the time of the appeal. But we know that's not true, because what happens here is that order is vacated and annulled. And what that means is it's as if it never occurred in the first place, and you put the parties back in the position they were at the beginning. And so that's why really what's happening here is not retroactive rate making at all. It's simply an adjustment that's necessary to conform the commission's order with this court's decision.
As I understand it, though, the original rate only goes into effect if the commission fails to modify within 9 months.
Well, there is a
Is that a fact?
It's a fact that there's a statutory calendar.
Well, that's they don't act within 9 months, the original rate goes into effect. So it's not void ab initio in that sense. The statute sets up a 9-month time frame for the commission to act.
So Justice Vigil, that's certainly that's a statutory provision that occurs when rates are filed. It governs those issues that are before the commission. But of course, what we have here is something different. What we have here is under 6211.1, there was an appeal of that unlawful rate order. And so what governs then is, because this court vacated and annulled that decision under 6211.5, then that means that original unlawful rate order simply, it's as if it's ceased to exist.
So we're going back to the original.
We're going back to the original. We're putting the parties back in the position that they were at the beginning.
So-
And that means that we have to say, okay, what was the valid rate at that time? Now, you could imagine two possibilities, right? One possibility would be whatever the rates were prior to the rate case being filed.
So let me read you a quote from Public Service Company versus New Mexico Public Service Commission, paragraph 24. Once the commission's order is annulled and vacated, a rate case is in the same posture it was in before the original decision was rendered. The commission may hold additional hearings and take additional testimony just as if the vacated order had never been entered. However, because the proposed rates may be put into effect after expiration of the initial 9-month period, the commission will have every reason to act expeditiously to enter new findings based on substantial evidence. So that after an order is annulled and vacated, it's remanded for further proceedings. And unless the commission timely acts to approve new rates, the rate to be charged will be the rate on file before the commission's vacated order. So it's not void ab initio automatically. The commission has 9 months to act.
Well, I think that, with all due respect, Your Honor, I do think you're confusing two different things. I think that 9 months.
Maybe I am.
I think that 9-month calendar applies to matters before the commission. I do think that when this court vacates and annuls a decision of the commission, a rate decision of the commission, that it is void ab initio. I think that the case law both here and in other states makes that crystal clear. Now, I do agree with you, and there's nothing in the paragraph that you just read that I disagree with. In fact, I think it supports our position. When the case goes back to the commission, it's as if the parties are in the place that they began, and what's necessary is then to make the necessary adjustment to conform the rates to what this court ruled. That's exactly what didn't happen here. It's true, the commission can hold additional proceedings and it could adopt a different rate so long as it addresses whatever the
That's
issues.
what would have to be perspective. That second, the second go around, the second bite at the apple here of a new rate making that, you know, in theory, none of you would appeal to us, which seems impossible. But that second rate making then would have to be what's perspective. You're talking about the gap between
Correct.
remands where you're going back to the original rate and the time in which that second decision is made.
Yes, that's exactly right. And as we said, we think basic fairness requires us to be able to make an adjustment to conform to what this court has held as rule.
And that
For that
gap
gap.
is not rate making because the rate making existed in creating that original rate.
That's correct. And then what happened as it occurred in this case is the commission simply adopted something that was illegal. It violated El Paso Electric's due process. And so you have to put the parties back in what is a legal position at the time it goes back on remand. I want to address the Mountain States question and whether it's controlling. I think, as you know, the commission relied heavily on Mountain States. And as you indicated, Justice Bacon, there's a lot of reasons to think that that is a very different decision. I mean, unlike in this case, there were no rates adopted by the commission in the first place. And part of what the court was struggling with was, well, can we, the court, adopt new rates? Answer is no, right? Because that is a largely a legislative function. The main question in that case really was, can we adopt interim rates, meaning the commission, can it adopt interim rates? And once the court found that, yes, in fact, you can do that, the question then turned to, okay, since we're going to allow them, in fact, they ordered them to adopt a new interim rate, what was the effective date of that new rate that was going to be put into place? And then so the court looked at this idea of, can it be retroactive? Can it go back, sort of allow Mountain States to recover some of these additional dollars? And the answer there is no, because they would be adopting a rate for the very first time. That is quintessentially retroactive rate making. You'd be putting in a rate today that changes a previous rate and tries to make up for a deficit. That is the definition of retroactive rate making. But as we've had very discussed at length here this morning, that's not what happened here. Rather, what you had here is a commission order found to be unlawful, vacated and annulled. And so on going back, it's necessary for basic fairness reasons in order to ensure that the law is followed, that an adjustment be made to allow El Paso Electric to recover for those underpayments that were caused by the violation of their due process. Turning then to West, US West, we think US West is, again, we'll acknowledge is not directly on point. The reason US West is not directly on point is because the court affirmed the decision of the commission. But really, there's a lot of things that were happening there analogously. And I want to make sure that you understand there that case under a provision that no longer exists in the Constitution, that case was removed to this court before those rates ever took effect. And the reason that ends up being important is because what ended up having to happen as a practical matter in that case is exactly what we're asking for here. And that is, US West there was not charging the new rates, they were charging the old rates. When this court ultimately said, look, we're going to affirm the decision of the commission, it still required going back to the commission. The commission needed to make an adjustment to ensure that a refund then in subsequent rates was allowed. That's precisely what we're asking for here. And so while we acknowledge not directly on point, if you extend the reasoning of US West, really, that supports our position and not the other side. Unless the court has any further questions.
So getting back, if the order is annulled, the original, the appeal from order, you say, is void ab initio.
I do.
Putting in place the original order, the original rate. But what you're arguing is that rate operate retrospectively to the interim while the appeal was pending, not prospectively from that date forward.
No, what I'm saying is basically if you're, an adjustment that needs to be made is basically putting in place the rates that were legal as if it were from the beginning. And that's sort of an extension of the fact that this is all part of the same case. Rate making
You're
is
asking
not
for
final.
adjustments that go back in time.
Well, as a technical matter, they go back in time, but really all it's doing is
Actually, they go back in time.
factually, however you want to describe that. But again, what's happening is fundamentally different than what happens with retroactive rate making. And so what happens with retroactive rate making is you have one rate say that starts, that is a valid rate. It must be a valid rate. And that causes either over or under earnings. And there's a subsequent rate, also a valid rate. And that one is simply trying to make up for that past rate. That is retroactive rate making. That's not what's occurring here, both because really it's all part of the same case. So rates aren't final until judicial review. And secondly, because what happens is this court
But if
has
there's no
vacated and
judicial,
annulled.
if there's no judicial review, the
If there's
rate
no-
never becomes effective?
If there's no judicial review, then the rates that were put in place by the commission would have gone into effect. And then subsequently, if El Paso Electric had come in for like a subsequent rate case and said, hey, we want to make up for those past deficits, that would be retroactive rate making. We would not be allowed to happen here. And that is why a different rule really has to apply in those circumstances when there is a rate case order that is found to be unlawful, that's vacated and annulled as if it never happened. And so really then all the commission is doing is the same thing that a court would do in the event that this court ruled on behalf of one of the litigants. And that is order an adjustment to conform to this court's decision and allow for valid rates to be put in place as if they were there from the very beginning.
Like, well, most of our litigants don't serve a legislative function. So that's what I struggle with. I do understand sort of this equity argument, except that seems to me the foundation of this retroactive rate concept is where it's either a matter of discretion to the PRC. They're serving that legislative function, so we don't really go back and do that part of it.
Well, I'm not sure that that's right, Justice Thompson. So I'll give you sort of two responses. I mean, first, it's true that you can't adopt a new rate. In other words, you couldn't come in and say, here's what needs to be charged going forward. However, I mean, think of the situation in which someone claims, look, my rights were violated by a legislative act, right? And my due process rights or whatever. And I go into court, whether it's state court or federal court, and I win. I am granted a remedy for that, sometimes a remedy in terms of monetary damages. And so that certainly happens in the law with some regularity. Thank you.
All right, first we'll hear from NMPRC. 2 minutes.
Good morning, Erin Lecoq on behalf of the Public Regulation Commission, Mr. Chief Justice, and may it please the court. This case turns on a foundational principle of public utility regulation in New Mexico. The legislature has vested the PRC with the authority and the responsibility to issue orders that are immediately effective, that must be relied upon, and that remain operative until or unless this court annuls and vacates that order.
Which we did.
Yes.
So if we did that,
Mhm.
what does that take us back to? I mean, I really question, I'm going to be super overt about this. I really question whether this is rate making. Because it's not, we didn't void and annul the new rate making order and then throw everyone into the abyss. It goes back to the original rate until such time as you do something different.
And
Super simple to me.
Well, I guess the question then is, what is the original rate? Is it the original rate that was vacated, or is it the rate, and in this case was the
Can't be the rate
2016?
vacated.
Exactly.
So
So,
we vacated something new. We didn't vacate the prior rate.
right. So,
Calm down over here. It's very distracting.
so if we have these 2016 rate, right, the last case that APE did was the rate case was in 2016. Those were the rates that were in effect until the commission issued a new order. I think one of the questions is this gap that Mr. Wexler is talking about. Which rate is in effect at that time? It cannot be that the new commission order that is established here in 2023 can go back. So it could be that the 2016 rate remains in effect, or it could be that the initial rate that was vacated, that is what it was in effect for those 2 years.
Still not
And-
following you.
So let me back up a little bit and talk about rate making in general. Rate making relies on current information. It relies on the ability of the ratepayer to pay the rates for the energy that ratepayer is putting into the system at the time. That, and there are other reasons really that the rule against retroactive rate making applies, but that is really the fundamental reason. The current rate has to reflect current cost allocation, current usage. That is one of the reasons I think Justice Vihil, that the legislature has given the commission a short timeline, 9 months plus 3 months, to go through a rate case, because it really relies on current information. If the commission issues an order based on current information, that order must be effective when the commission orders it. The legislature has vested the commission with the authority to issue these orders. And it has also said in 6211.6 that a pendency of an appeal shall not stay the commission's order. That order goes into effect when it is issued. Now, if that order is wrong, we can't go back. We can't have ratepayers from 2021 pay for the usage that's happening in 2023. It does sound unfair, and I will grant you that, but that is the system that we have. That's the system the legislature has given
Then
us.
what's the rate? If we have said your rate is illegal, we can't enforce that rate.
And Justice
So
Bacon,
what's the rate?
I'm going to push back on that. The court doesn't say the rate is illegal. The court says the order is illegal. And it
But
has
when
to go-
we issue an order, we are in an all or nothing proposition in the PRC
Mhm.
cases.
Mhm.
When we say, no, you've done something wrong, the entirety is undone.
Yes.
It is unlike any other civil proceeding in that way. So there's nothing to go back to in the 2023 rate making because it doesn't exist. You have to start over.
We have to start over.
And if you're starting over, it means the prior rate is in place.
Well, I'm actually going to, so Mr. Wexler talked about if his rights were violated by a legislative act, what is the remedy there? And I think this is similar, right? If the rights are violated by a statute and that statute is found to be unconstitutional, do we go back? And we do not. We do not implement a statute that is retroactive. And that is the same thing here. So the rate that is in place is the rate that was in place between 2021 and 2023. It has to be, because the people in New Mexico have to be able to rely on the commission order when it is issued. That is what the legislature has said. And if that rate is wrong, this is what Mountain States says, then and granted, Mountain States is a slightly different fact pattern, but Mountain States is the seminal case.
It's a
of this.
lot different fact.
It is, but the holding itself that that the court looked to see if we could impose a rate that predated the court's mandate, it said, no, we cannot. The date that that order is annulled, that is the date that the rate can no longer be effective. To rule otherwise, to make a rule otherwise would essentially weaken the commission. It would make it so that nobody would have to rely on an order of the commission until this court says you either do or don't. And that cannot be what the legislature intended. The legislature, I think, is very clear about this, particularly if you look at 6211.6. It says it shall not be suspended pending an appeal, which means that rate has to be in effect pending the appeal. And I understand the confusion.
Let me ask you, if they had filed a stay and we stayed the current, or the order at issue, what rate would be applied then, once that stays filed, once we grant the stay? What
I
rate?
think the initial rate, the 2016, in this case, it would be the
The one-
2016 rates would remain in effect.
Okay.
And, you know, that, because that, the order of the commission has been stayed either by the commission or by this court. That is the remedy that the legislature has given us. And Justice Thomas.
I want you to finish.
Okay.
I
I
do have a follow-up on that.
Okay.
Go ahead and finish.
But that is the remedy the legislature has given us. So if you look at, if you look at and this, it's difficult because the legislature has given us a constellation of statutes that really need to be interpreted. But if you look at what the legislature really intended by giving the commission exclusive authority to set a rate, and then saying that this order will be in effect during the pendency of an appeal, and then saying, if you don't like this order, if you think something's wrong with this order, here is your remedy. It is a stay, which will prevent that order from being in effect.
Except they require a bond, right?
They don't require a bond. It says may, I think, may issue a bond, I believe.
They issue a bond to secure the other party, in this case, you, right?
But,
Against loss due to the delay in the enforcement of the order.
and I think
Now,
that,
that seems to me fairly similar to what they're asking for here. Not, so my question, to be specific, is why would that not, in essence, violate retroactive rate making?
well, I don't.
They're
I think-
just doing, it just seems like it's a flip of what they're asking for.
I think because if it was maybe, but this is the remedy the legislature gave us. That is the remedy that has to be followed. And because EPE didn't even seek a stay, we don't know. We don't know what could have been the remedy here. But I don't think it would be retroactive rate making because it would have been a bond that would have been issued, that's allowed to be issued by this court and not the commission. Only the commission can set a rate. But if the legislature is giving this court the ability to issue a bond, then that's a bond would be different than a rate. It might have the same results and the same effect at the end of the day, which perhaps is why the legislature put it in there in the first place.
So they've only given a remedy to the PRC, right? Because if we entered that state, let's say we entered that state, we decided later, shouldn't have done it. You're protected by a bond.
Well, and it so possibly, but it does say may. And it also I think this court has, as long as the court isn't setting a rate, I think the court has the ability, a kind of broad ability to determine what is the remedy that's going to be in place within that stay.
But if there's no bond, because it's discretionary,
Mhm.
say, we don't believe in bonds. And then they prevail,
Mhm.
it's the same thing that they're asking for here. Going back to 2016.
Yes, perhaps. But,
I don't think it's perhaps, it's nothing else.
well,
I mean, legally, it would be going back to 2016, and that's exactly what El Paso is advocating for here. So what's the difference?
I don't think El Paso is advocating going back to 2016. They're asking for a remedy from the 2023 rate that goes back to 2021. That's what they want. That's what the commission cannot provide. That's what I don't think this court can provide. And I hate to say it, but that is the system that we're given. And it is based on a reliability that ratepayers, utilities, investors, people in New Mexico have to be able to rely on a rate that is set by the commission on the day that it is set. That otherwise the commission loses a significant amount of power. And that is not what the legislature intended. It cannot be. And so it sounds insensitive and it sounds unfair, but the system has to be reliable. And sometimes the utilities win and sometimes the ratepayers win, and it does balance out in the end. I think Mr. Wexler here is advocating for this perfect system it would be lovely if that perfect system existed. But the commission is not required to issue a perfect rate. It has to be a reasonable rate within the zone of reasonableness. Sometimes you lose money. Sometimes you have more money. This is the balancing system that is put in place for the commission. This is what is the best system that we have, and it's the best system because it is reliable. And again, everybody in New Mexico, we have to be able to rely on the commission's order as soon as that order is issued. It cannot be a tentative order unless the court changes it, and then it goes back, and then people in 2021 have to pay the rates in 2023. That is why we have this rule against retroactive rate making.
So if I understand your colloquy with Justice Bacon, it is that if Mr. Wexler is right, a stay serves no function. It's getting a statutory stay serves no function because you're staying the enforcement of the new order. And at the end of the case, win or lose or draw, I mean, if they lose, they go back to the original. I mean, you get a stay. And then if you lose, you've got the stay in place. And so you were able to recover the differences during the pendency of the appeal. So if I'm understanding right, under that scenario, and maybe Mr. Wexler can correct me if I'm wrong, but it seems like a stay you don't need a stay. Why would you apply for a stay if it goes back up ab initio? If it's void ab initio and you're going back to the original rate? Am I making?
I think so, Justice Fields. Let me try to answer it, and if I'm not answering it, please tell me. In this case, the 2016 rates were higher than the 2021 rate that was put in place. So EPE would be able to continue to collect this higher rate until 2023, when this court vacated and annulled that issue. So they would
Stay.
under a stay, yes. So they wouldn't, they would still be recovering this higher rate. And this is why I think it would be as if that order was not put in place. That 2021 order is not put in place. That's what a stay does, right? It prevents that order from being put in place. It fills in the gap.
So that when the 2021 is vacated, as I understand Mr. Wexler's argument, we go back to the 2016.
Well, when the
And any rate adjustments that are, he's saying the rate adjustments are not new rate making, they're just simply adjustments. So
well,
why would you ask for a stay under that scenario?
if that order is vacated, then the new rate in 2023, that is the order that would be put in place. And that is a rate making order. It's not just an adjustment, because if that order is vacated, then there's no rates. So the 2016 order would carry through to 2023. The commission would issue a new order in 2023, but with setting the 2023 rate. And so then that fills in the gap. So I think a stay is exactly what that is the mechanism the legislature has given us to answer this question of what fills in the gap between 2020 and
The
2020.
language of public service company versus P&M from 1979, because I know we have a bunch of those cases. It says, once the commission's order is annulled and vacated, a rate case is in the same posture it was in before the original decision was rendered. Meaning, before the PRC renders a decision, it's that 2016 rate that's in effect. And that's what that says.
Well, and I think that's right, Justice Bacon. That 2016 rate would be in effect until
Until you do something new.
we do something new. But the thing is that the thing that we
That's
do,
not rate making. That's my point.
it has to, but Justice Bacon, it has to be rate making.
No, because you've already, the rate making happened to establish the 2016 number, whatever that number, play with me. The number is 10.
Right.
Because I want to get into the real numbers. But in 2016, you said you can charge 10.
Mhm.
Then you move forward in time to the new rate making. You say, you're making that was too big a swing. Now it's going to be 8. We vacate 8.
Mhm.
You go back to 10 until you do something different.
That's right.
That's the gap I'm talking about.
I think we
That's
agree.
not rate making.
I think
You've already established the rate when you put it in place in 2016.
I think we agree, Justice Bacon. But let me rephrase it, because I think it is a rate. So let me rephrase this. So 2016, the commission says you can charge 10. They charge 10. In 2021, the commission says you can charge 8. We start charging 8 in 2021. In 2023, the court says, nope, you can't charge 8. Go back. And the commission says, oh, you're right, we can charge 9. So then they can charge 9 starting in 2023. The new rate, the 9, is a new rate. We can't, it has to be a new rate. And because of that, it can't go back to 2021. But
I get that.
right, but go ahead.
You still have the 2019 to 2023.
Mhm.
That's governed by the 2016.
Yes,
That is not rate making.
that's right. It would be the 2016 rate. That's right.
That's,
Yes. I think we agree.
I will yell at Mr. Wexler. Maybe.
I think we're saying this, maybe, Justice Moore, I think you're right. Yes.
Go ahead.
At least it's not me that's doing the yelling. That's,
I
We had a
think,
disclaimer in the last.
Yeah,
comments.
the three of us are yelling, but I'm not actually yelling.
I think we're saying the same thing. And I think the difference here is that the 8 that we could have charged disappears. But the 9 cannot go back to 2021. That is the point.
Okay, I follow that, but I'm gonna press on this guy over here in a minute.
I want to, let's see.
So, Mr. Wexler suggests that mountain states would not need to be disturbed. Right? What is your response to that?
I agree Mountain States doesn't need to be disturbed. I think Mountain States, what it stands for, what it does say. No, Justice Thompson, go ahead.
He made several compelling arguments that Mountain States was a different case than what we have here.
Mhm.
Maybe address those specifically.
It is a different case than what we have here, but the holding itself, the holding that the court looked to see whether interim rate relief, which maybe is another word for this, right? It's that interim, it fills in the gap. And yes, the facts are different. It's a telecom case, which is very different from an electricity case. The facts are different, but that holding, that interim rate relief cannot predate this court's mandate. That is what needs to apply. Mountain States has been cited over 37 times in PRC cases. That it is foundational for this kind of idea that once a rate is established by the commission, the date that rate is annulled and vacated has to be the date of the Supreme Court's mandate saying it is annulled and vacated. We cannot go back. And so, yeah, the facts are different, but the holding really, that is what applies, and it applies across the board to telecom, to electricity, to water.
So I want to play with my 10, 8, 9, just to make sure.
Okay.
Please.
So say that in 2016, the old rate was 100.
Mhm.
And in 2019, you change it to 8. That's a big, big difference.
Mhm.
And then in 2023, we say, no, 8's ridiculous. And then you know, within the 9 months or whatever, you say, okay, it's 9.
Mhm.
Despite the fact that there is that enormous difference between 100 and 8, that's the rate that would be in place as the 100.
Yes.
And they would be able to collect on that.
If
They had not filed a stay.
they had not filed a stay. Yes.
Okay.
I think so.
That also seems ludicrous.
They had not filed a stay.
So I think it's, I mean, if you think, and I'm
I used an extreme example on purpose to test that.
right. I mean, I think that that's really, it does seem a little bit ludicrous. And I think that's why the legislature gave us the ability to ask for a stay, right? That it,
Can you ask for a stay?
I don't,
Like if you had that extreme and you're like, oh
Yeah.
God, if we lose.
Yeah.
We're gonna go back to this outrageous rate.
Yeah.
Oddly, you blessed in the first place. But would you be able to ask for a stay in that scenario and say, we're gonna go get the court's blessing before we pull the trigger?
let me see what the statute
I
says.
honestly don't know the answer to this
I
question.
don't
It
know.
says the Supreme Court in its discretion may stay or suspend.
Doesn't really say who.
No,
Doesn't.
Ask for it.
someone needs to ask.
So based on my very quick interpretation of the statute, I would say yes. Right, because again, those rates need to be, it's just and reasonable, and the rate needs to be relied upon at the time that it's issued. And I think really that is the main takeaway here, is that adopting the rule that Mr. Wexler is asking for would weaken the commission's ability to issue an order that can be relied upon. And that is essential. It is essential. The legislature has said it's essential, that the system that we have in place, while imperfect, I grant you, is reliable. And ratepayers need to rely on it. Utilities need to rely on it. Investors who are making decisions right now as to whether to invest millions and millions of dollars into energy in New Mexico, they need to be able to rely on that. They can't say, oh, this rate that is issued in 2021, maybe it's going to change, maybe it's not. That would upend the system that we have here. I know that there are other states that have adopted this, but we have to look at New Mexico. We have to look at New Mexico. The resources that we have here, the capital we have here, the people we have here. That is why here in New Mexico, that's why Mountain States has been in control for so long. That is the system that we have, and that system is reliable, and that system needs to stay in place. Unless there are any other questions, I think. Done. Thank you.
From the New Mexico Attorney General's office, 8 minutes.
Thank you, Your Honors. Lawrence Marcus on behalf of the NMDOJ, and with me are Anastasia Stevens, representing the city of Las Cruces, and Keith Herman, representing Doña Ana County. The interveners represent the interests of the ratepayers, the small residential and small business ratepayers, and some municipal ratepayers as well. From this perspective, the PRC decision should be upheld. As has been noted, the rate-making process is legislative or prospective. What are you trying to do? You're trying to determine the value of a kilowatt hour, of a unit of electricity, the fair market price of it, for the next few years. This fair market price is not, this fair market price in the future is not affected by perhaps an underpayment in the past. It doesn't change what the value of a kilowatt hour is for the next few years. And that's what we're doing here. We're trying to determine the prospective value of a kilowatt hour. And what Mr. Wexler is asking for, and he admitted it, is different. Essentially, what he is asking for is damages. He's asking for, which is the very definition of retrospective relief,
I may accept that concept, except you seem to be able to get damages under 6211.6 and they don't. If we granted a stay, PRC increased our rate, we granted the stay and said, nope, it's $8.
Okay.
You can go back and then we decide that we were wrong. Go ahead and charge 100. You can go back and either through the bond or I assume other means recover that loss. It says loss, but they can't. Is that just the nature of this legislative function?
That's the statute. That any change to that would be a question for the legislature rather than a question for this court. And so they're seeking damages, and they're not seeking damages. So let's say the PRC, this court, and with all due respect to Ms. Lecoq, this court determined a couple of years ago that the PRC made a mistake. They made a procedural error that resulted in underpayments. But so Mr. Wexler is saying, well, we want to seek damages against future ratepayers, the future ratepayers of southern New Mexico, of El Paso, of Las Cruces, of Doña Ana County. That's not a true damages claim. They're seeking damages against a completely different party, Your Honors. And not only that, but this could be several years in the future because they didn't seek to bake these damages into the rates that went into effect at the beginning of 2024. They are trying to float a regulatory asset. They're trying to book a sum of money in order to obtain higher rates down the road whenever, and who knows when that's going to be, whenever they file their next rate case, file next application. And not only that, but they are seeking carrying costs as well. They're seeking the 7 point whatever % of return on investment that they are generally allowed. And those carrying costs are just going to increase the amount of money that they're going to seek from future ratepayers way down the line. So they're trying to get damages from the wrong party, essentially. They are trying to get retrospective relief in the form of rates. And that is the very definition of retroactive rate making, Your Honors. That is, and that's what they are seeking. And that is entirely inappropriate based on Mountain States. Now, let's say that the rates that were put into place were invalidated ab initio. Let's say that were the case. Then we are basically, yes, there are differences between this case and Mountain States, but it's basically the same idea. There were no valid rates issued for a particular period of time. And you still can't do a retroactive rate to make up for that. Secondly, they did not really even suffer any damages. Essentially, the rates are determined based on a fair revenue requirement. And in the record, the PRC originally determined that a fair annual revenue requirement was 117.1 million. And so then they appealed. The court found for EPE on only 3 of their 13 appellate issues, and they found that 3 disallowances weren't appropriate. So based on this, the EPE presented revised rates based on a revenue requirement of approximately 117.6 million. However, for a 12-month period, while the old rates were in effect, while these rates that were based on the order that was reversed, this was a period between September of 21 and August of 22, EPE received $126 million of revenue, over 8 more than the revised revenue requirement. So they actually got what this court believed was their revenue requirement, essentially believed what the revenue requirement was. And so therefore, they met their, not only did they meet their investment-based expectations, these expectations were exceeded. So if you have no other questions, I believe that I am done.
Thank you, counsel.
Thank you very much, Your Honors.
I want to address the stability argument that's made, and then I'll turn to the 10-9, which I assume that there'll be many questions about that. So the commission relied pretty heavily on this idea. In fact, the only argument that I heard in terms of like, why is this rule a bad one, is because of the somehow stability in rates, right? And I want to make 3 points about that. The first one is that built into the statutes is the ability to have judicial review. And so it is known to all of the parties, all of the customers, the utilities, that unless and until judicial review is complete, there is no expectation in what that rate is going to be. So that expectation, that stability interest that they are arguing for simply doesn't exist. It also doesn't exist for my second point, and that is there can't be any expectation of reasonable expectation in the ability to retain illegal rates. In other words, EPE's rights, due process rights were violated here. There can't be any expectation interest in retaining those ill-gotten gains. And my third point is my friend from the commission suggested that somehow New Mexico was unique, like the statutory scheme, the regulatory scheme here was different. But that's not so. Really, courts have been grappling with this exact same issue, dealing with the exact same, and as I said, the very, very strong majority has shown that, in fact, there is a fair way to deal with this. And it rests on the principle that, Justice Bacon, that you have articulated multiple times, and that is, this simply isn't rate making. And so there's no problem with a retroactive remedy if it's not rate making. It is the rate making part that adds to that. Will do.
Brain size type and tell me what rate would be in place between 2019 and 2023.
I think that, I mean, there's 2 possibilities, right? Either you go back to 2026 and your hypothetical, it was the 10, right? I'm sorry, 2016, my apologies. Correct, yeah. Or the other alternative is you basically use what came into place in 2023 with the adjustments that are necessary to ensure that the due process rights are in place. And we'll accept either.
Well, of course you'll accept 2016.
It is higher, that's correct.
So it's better for you to argue.
But that's not always going to be true, right? But as a matter of, yeah, from a principled standpoint, it makes sense. From a logical standpoint, we do think that the better rule probably is use 2023 and make the adjustments that are necessary to.
See, that's where I think
Well, we're
maybe throwing a softball across the plate for you. But to me, using the 2023 rate to cover the gap is retroactive. Because the rate, we voided the whole darn thing
Fair.
So you're creating a new rate, even though it ended up being the same rate? You went from 8 to 8?
Understand that logic.
That to me is backwards, but if you went back to 2016.
Right. Understood.
It's not, because that rate was already established. So I'm maybe landing on
your papers, neither side was right.
Well, yeah.
You might be coming up with something that's
Understood.
right now.
And I understand the logical basis for that, and I accept that 2016 is a reasonable conclusion there. Now, what I would say there is because it's not rate making, as you said, because you didn't have, you're going back to the beginning of
And
the
all the
case.
process
Yeah,
was baked into the.
exactly, yeah, and that's true. But because it's not rate making, there's really no prohibition on doing something to retroactively correct. And I'll give you some examples, like as
Can I
I
just
mentioned, please.
Clarify. She's way better at her hypothetical, but. So you're saying, in this case, the PRC, you didn't ask for the 2016 rate, you asked for the 2023 with some adjustments, right?
Well, so if you're going back to when we originally filed our case, the rate case, we were ordered to file the rate case by the commission. So we were following that. We were perfectly content with the 2016 rates.
Okay.
Yeah.
And the pleadings to the PRC.
That's right.
Okay.
Yeah.
But in the case in front of us.
We asked for, what we asked for,
2023 with adjustment.
we asked for something very different than what the commission ultimately ordered. Our application would have been included significantly tens of millions of dollars additional in rate base, but we were denied that, right? And so
it's premised on the 2023 rate, not the 2016.
yes, that's correct. So going back to this idea that in fact, this court has endorsed retroactive remedies in the past that just don't have to do with rate making. As I pointed out in US West, that happened where, the commission was forced to go back and make these adjustments to allow for the refund. You have endorsed regulatory assets, which is exactly what we're asking for here. In the Quest case in which we pointed out, you very expressly articulated that there's no problem with a retroactive remedy. It's just when it becomes rate making. And for all of the reasons that we've articulated, that Justice Bacon has articulated, this simply isn't rate making. Now, I heard from the commission a concession that this really isn't fair. That really this leads to a number of unfair outcomes. And again, I would urge this court to reject that concept because this isn't rate making to begin with. There's nothing to prohibit this court from ordering adjustments necessary to go back to, to allow for rates that are put into place that are fair, just, and do not violate the rights of the litigants.
The money you're asking for is from future ratepayers or for money that you didn't get in the past.
Yeah, that's not.
Isn't that kind of the rationale behind the rules so that there's some reliability in what the consumer can rely on?
I don't think that's the rationale that the court has articulated. It's really the legislative rationale. But I will say, that's just simply not that uncommon. As I
But wouldn't
mentioned.
it follow then that if a law's passed and the whole state's like, this is the law A, and that's what we follow. And then we say law A is unconstitutional. We wouldn't say, okay, but everyone who relied on it prior to our ruling. I thought that was what they meant by the legislative argument. Am I wrong?
Can I answer?
Yes.
I think the legislative argument, as this court and other courts have articulated, really is that legislative functions are prospective. And to the point that it's different rate makers or customers that might be paying. I'm not sure that that's true. That's always the case. It was the case in US West. It was the case in Quest. It was the case with regulatory assets. And that was no impediment. And really what we're talking about here is by and large, you have a large class of customers who didn't pay a fair rate for their service. And there can't be any expectation interest in maintaining that.
Along the lines of Senior Justice, I have a similar question. Why would the legislature have a state proceeding if they contemplated your ability to recover it the way you're asking for?
I don't think that. Yeah, I think that that's just not something that the legislature considered, right? If the legislature wanted this to be the exclusive remedy, it would have said so. It didn't say that. It's very clearly, it's simply in the discretion of both the litigant and the court. And as we've talked about here, will lead to some very absurd results and would be a really an incomplete relief because there'd be often times where you still would have to have this kind of true up at the end of the case. I ask that you vacate and annul the commission's decision.
S-1-SC-40286, Paso Electric versus Public Regulation Commission is under advisement is deemed submitted. Court is in recess till this afternoon.
The court convenes.